Well, good morning, everyone. My name is Jay Lyman. I'm a librarian with the Seattle Public Library. Thank you for being here for this overview of intellectual property. I'm super excited because I know that there are many people who have questions about what intellectual property is, how you can protect your intellectual property, and we're going to cover a lot of that today here. So I'm going to turn things over to my colleague here, Professor Jennifer Fan with the University of Washington Entrepreneurial Law Clinic. Jennifer, Jennifer's going to introduce our speakers this morning, and thank you for being here.
Thanks so much, Jay. We're very excited to welcome the USPTO today to give this overview of intellectual property law. And I just wanted to start off by introducing Bahram Parbadia, who's a primary patent examiner at the United States Patent and Trademark Office with a focus in the optical systems technology, which includes display systems, camera modules, virtual reality devices, and optical films. He additionally serves as an assistant outreach coordinator for the Western Regional Office, where the outreach efforts include programs for inventors, entrepreneurs, K-12 STEM activities, and other communities in the Western region. Bahram joined the USPTO in 2014 and has a BS in electrical engineering from Virginia Tech. Also from the USPTO, we have Julie Mason, who's the regional outreach officer, and Gautam Ubali, a primary patent examiner for business methods. So with that, I'll turn it over to Bahram. Thanks so much again for giving this presentation.
All right, thank you so much for that introduction. Am I good on audio and video? All right, good morning, everybody. Happy post-daylight savings Monday. Thank you all for joining, and thanks again for the introduction. We do have great content to go over today, but before I get started, I want to give a brief disclaimer that the content presented today is for informational purposes, and it shouldn't be considered as legal advice. You should consult with the appropriate sources for legal authority and guidance on these matters. That being said, let's jump into today's presentation. So, when filing for patents and trademarks, you go through the United States Patent and Trademark Office, or the USPTO. Here's a picture of our headquarters in Alexandria, Virginia. It's got a cool Inventors museum on the first floor, which is open to the public. So if you're ever in the DC area, you can swing by and check it out. So our goal is to foster innovation and economic growth, as well as create a reliable, predictable, and high-quality intellectual property system. And although the USPTO is a federal agency, it is a fee-based agency as opposed to being funded by tax dollars. And apart from headquarters being in Virginia, there are also 4 regional offices across the US, and they're located in Detroit, Denver, Dallas, and San Jose. So I have some stats up here from fiscal year 2021, where we can see that the USPTO had about 13,000 employees, of which 8,000 were patent examiners and 662 were trademark examiners. There's also respective patent and trademark trial and appeal board teams, which are utilized for when applications need to be further reviewed after a disputed final rejection. Also in fiscal year 2021, the USPTO had about 650,000 patent applications filed, with about 374,000 patents issued. Now, on the trademark side, there were about 732,000 trademark applications filed and roughly 337,000 certificates of registration issued. So with that background on what the USPTO is, today I mainly wanted to go over the first 3 steps listed in this diagram, which is determining the type of IP protection you need, determining if your invention is patentable, and determining what kind of patent you need. So the idea for today's presentation is to give you a solid foundation for next Monday's discussion, which will really dig into the patent process. Now, as I mentioned before, the USPTO is a fee-based agency, and additionally, it's strongly encouraged to pursue your intellectual property rights with the help of an attorney in the field of your invention, because that'll allow you to obtain your rights much more efficiently. That being said, the cost of an attorney plus the USPTO fees could add up really quickly. And so it's important for whoever is pursuing a patent or trademark to have a nice, strong base and understanding of this process. Having this knowledge actually reduces costs significantly, especially your attorney fees, because that's less billable hours that the attorney would then have to charge you to bring you up to speed. So hopefully with today's and next week's presentation, you'll have effectively built up your IP knowledge foundation so that it can save you those dollars. So what is intellectual property? Well, just like a fence defines the physical boundaries of property that belongs to you, intellectual property defines the metes and bounds, or it's the legal fence around an intangible property like an idea. So the legal ownership of intellectual property allows its owner to exclude other people from using the ideas or concepts that comprise the intellectual property at issue. So the first step is to determine the type of IP protection that you need for your idea. Now, what I mean by type is best illustrated here on this next slide. So as we can see, there's 4 different categories or types of intellectual property. We have patents, trademarks, copyrights, and trade secrets. So first, patents give you the legal right to exclude others from making, using, selling, or importing your claimed invention for a limited term. Now, that term could be 15 or 20 years, depending on which type of patent it is. Now, trademarks protect brands as well as consumers because they identify the source of the goods or services. Trademarks allow for customers to know who they're doing business with, and the term for protection lasts for as long as the mark is in continuous use in connection with that good or service. Now, copyrights protect creative works. So think in terms of music, books, or choreography. So the term for copyrights is the life of the author plus 70 years after the author's death. For works made for hire and anonymous works, copyright protection would be 95 years from publication or 120 years from creation, whichever is shorter. And finally, trade secrets, they're just what they sound like, secrets. So the effectiveness of your trade secret is determined by how well you or your organization can keep that idea under wraps. So for trade secrets, it's important to know that the USPTO neither reviews nor regulates trade secrets. It's up to the individual or the business to maintain that trade secret. So some examples of trade secrets include KFC's recipe, the Google search algorithm, and the recipe for Coca-Cola. So if you have formulas, patterns, programs, devices, methods, techniques, or processes, you may want to consider protection via a trade secret. So different factors to consider when determining to use a trade secret as your means of IP protection include things like figuring out what the value is in having the information against competitors, what precautions are taken to guard the information, what is the amount of money and effort expended in obtaining and developing that information, and also evaluating the time and expense for others to acquire and duplicate the information. Which brings me to my next point on ways to lose a trade secret. So as we know, trade secrets are maintained within company confines. They're generally protected by signed agreements between employees and companies. Now, these contracts may require non-disclosure of proprietary information and non-competition after leaving employment. This is a good example of what falls within a level of reasonable effort to maintain secrecy and to keep the information out of the public domain. However, without these legal agreements, you may lose benefit of your trade secret. Another way you'd lose your trade secret is by competitors reverse engineering your product. That's why we don't too often see a physical machine or apparatus being a trade secret. Now, with today's technology, it's hard to imagine you wouldn't be able to reverse engineer the formula for something like Coca-Cola. However, due to their trademarks and marketing efforts, their marks are now much more valuable than their formula or ingredients. So as you can see, in the real world, intellectual property protection can easily be utilized as a holistic ecosystem, where initially you would have a trade secret, but then later you utilize trademarking as your business strategy. Now, one last item to note about trade secrets is that the Defend Trade Secrets Act of 2016 made it possible for an owner of a trade secret to sue an entity in federal court when their trade secrets have been misappropriated. So, for example, if a former employee left the company and tells a competitor the trade secret, well, now they'd be liable to a federal lawsuit. Moving on to copyrights, a copyright is a form of protection provided by the laws of the United States to authors of original works of authorship, including things like literary, dramatic, musical, artistic, and other intellectual works. So copyright is a bundle of rights that gives the owner the right to make and distribute copies, prepare modified works, and perform or display their work publicly. So it's important to know that we are all also copyright users. When we read books, watch movies, listen to music, or play video games, we're all using copyright protected works. So even if you're not the owner of the work, you still may be able to use it. In addition to buying or licensing works, you can also use one of the Copyright Act's exemptions and limitations, which can be found in Chapter 1 of Title 17 of the United States Code, or you can rely on works in the public domain. Now, works in the public domain are basically just things that have never been protected by copyright, such as facts or discoveries, or they could be works whose term of protection has ended, either because it expired or the owner did not satisfy a previously required formality. So currently, all pre-1926 US works are considered to be in the public domain because copyright protection has expired for those works. The Copyright Office is part of the Library of Congress, and additionally, the Undersecretary of Commerce for Intellectual Property also has oversight authority on copyrights. Now, copyright.gov is a great place to get complete and reliable information if you are interested in learning more about copyrighting your work. Moving on to trademarks and service marks. They can be anything such as symbols, pictures, words, phrases, slogans, really anything that helps you identify the source of the product or the goods or services. So there's two different types of trademarks, which include common law trademark and registered trademarks. Now, with common law trademarks, they're much more easier to obtain. However, they grant their owners much less protection. Common law trademarks are trademarks that are used in commerce in connection with specified goods and services, but they're not registered. So your rights are limited to that geographical area where your product or that service is in use. And they're signified by the TM or the SM symbol. Now, a registered trademark dictated by the circle R provides a public notice of claim of ownership. It gives the legal presumption of ownership an exclusive right to use the mark in the entirety of the U.S. in connection with the good or service listed in the registration. You'd also be much better equipped to protect your trademark if it's registered, because it gives you the ability to bring an action in federal court. And additionally, it may be recorded with the U.S. Customs to prevent importation of infringing foreign goods. So here we can see traditional examples of trademarks, which can be words or logos and symbols. You can also trademark non-traditional things like colors. Now, with colors such as the Tiffany blue of Tiffany & Co., the brown of UPS, and the green and yellow of John Deere, there is a nuance on how colors are trademarked. The trademarked color has to be specific to a particular class of goods or service. Another trademark that can be pursued is scents, such as the strawberry, cherry, and grape scents of lubricants for engines to make an exhaust smell. A couple of other examples would include the flowery musk scent in Verizon stores and Plato's scent of a sweet, slightly musky vanilla fragrance with slight overtones of cherry combined with the smell of a salted wheat-based dough. We also have sounds as another source of trademarks. So popular trademark sounds include the NBC chime, the MGM lion roar, and the Pillsbury Doughboy sound, and that Mario coin sound. And finally, we have trade dress. So a trade dress is intended to protect consumers from packaging or appearance of products that are designed to imitate other products. So a trade dress must be non-functional and distinctive. This means that consumers perceive a particular trade dress as identifying a source of a product or service. Now, over time and with advertising and exposure, consumers associate the design with the source of the product. So some examples of trade dress would include Dr. Martens boots, the interior design of Apple Store, the shape of Hershey's Kisses, and Coca-Cola's bottle shape. And finally, we get to the last type of intellectual property, patents. So a U.S. patent is a property right granted by the U.S. government to an inventor, and it gives the right to exclude others from making, using, selling, or importing the invention through the U.S. for a duration of your patent term. So in exchange for this protection, a patent application provides public disclosure of the invention so that the public can benefit from it and expand on it. So why get a patent? Well, patents can give you entry into a market. They can deter others from entering your market. You can use them as collateral for funding. They can create revenue from licensing or sales. And you can use a patent as a marketing tool. So the moment you file for a provisional or non-provisional application, you can market your product as patent pending. Now, let's say you've determined that you want patent protection. The next step is to determine if your invention is patentable. So to measure the eligibility, we refer to 35 USC 101. And USC is just short for United States Code. So in essence, your idea has to be a process, a machine, a manufacture, or a composition of matter. Now, a process is a method, operation, or series of actions that are intended to achieve some result. So an example in my optical field would be the process to manufacture a lens, which would include the steps of cutting, etching, and molding. A machine is considered to be a device consisting of fixed or moving parts that work together to form some function. So an example would be a device like a handheld camera. And manufacture is a thing that is man or machine made as distinguished from something that's a product of nature. So a good example of a manufacture would be a trash bin because it has utility, but it's not a machine. And a composition of matter is a material composed of two or more different substances. So some examples would include things like pharmaceutical drugs or special forms of adhesives. So if your idea falls into one of these categories, then it would overcome 35 USC 101. So now that you've determined that your invention is patentable, next you want to determine what kind of patent you need. So there are three different types of patents that you can apply for. The first, which I exclusively examine, and which is most common, falls under the category of a utility patent. Now, the other two types of patents include design patents and plant patents. So for utility and plant patents, your term for protection would be 20 years after the filing date. And for a design patent, your term would be 15 years after the patent grant date. So I just went over utility patents in the previous slide, and some examples of that would be considered as a utility patent, was the handheld camera or the way of manufacturing the lens. Now, for design patents, it's really more about the ornamental structure or the shape of the device. So simply put, a design patent is for how something looks, not necessarily the function or how the device works. So some examples of a design patent would be jewelry, packaging, or computer icons like emojis. And finally, the third type of patent is a plant patent, which includes a new variety of plant that is asexually reproduced. So for one of my favorite snacks that I typically reach for, cotton candy grapes, they'd be categorized as plant patents. Now, it's important to note that the USPTO is not an enforcement agency. In order to enforce a patent, the onus is actually on the owner, and it can be done by monitoring the marketplace for infringing products and taking appropriate measures to the infringement when it is found. So some enforcement resources would include stopfakes.gov and Customs and Border Protection. So stopfakes.gov is managed by the International Trade Administration, or the ITA, which is also a part of the Department of Commerce, and it assists U.S. businesses in protecting and enforcing their intellectual property rights against counterfeits and pirated goods in the global marketplace. StopFakes.gov also provides information, guidance, and trainings for businesses and consumers by both industry and country of interest. And Customs and Border Protection can detain and seize imported goods which violate intellectual property rights in the US. Now, before I conclude, I think it's extremely important for you all to know what help is available for you. Now, as I mentioned earlier, we do have 4 regional offices, which include offices in Detroit, Denver, Dallas, and San Jose. So the regional offices work closely with intellectual property practitioners, startups, and job growth accelerators. They also collaborate with local science, technology, engineering, and mathematics organizations on outreach and education programming. So from the USPTO homepage, you can actually navigate to the top left corner and click on Patents, and here you'll see a screen that provides links to resources for patents, including filing an application on your own and the Inventors Assistance Center. This page has a link for application assistance and patent process step-by-step filing guide. Now, the next one over is a link on trademarks, which will provide you all the resources for filing trademarks. Here's another useful site, www.uspto.gov/inventors, where you can learn a lot more detailed information, including performing searches on inventive concepts. We have great services available to the public, including application assistance, education, and training. And I can't stress this enough, that if you're stuck on where to go or who to reach out to, this website, uspto.gov/free services, is tremendous and has been compiled so comprehensively that you'll be able to find the right place you need to be to get your questions answered. There's also the IAC, or the Inventors Assistance Center, which is staffed by former supervisory patent examiners and experienced former primary examiners, and they can answer general questions concerning patent examining policy and procedure. So different things that the IAC can do is things like answering general questions regarding patent examining policy, answering questions concerning necessary formats and items needed for your patent application, They can assist you with forms needed and with filling out those forms. They can also direct your calls to appropriate USPTO personnel and also provide you general information concerning patent examining rules, procedures, and fees. Now, what the IAC can't do for you is give you an actual opinion onto whether your invention is patentable or not. They can't provide legal advice or legal interpretation, and they can't provide patent searches or other intellectual property research. So another great resource is the Patent Pro Bono program, where you can find out more information on the link on the slide. So basically, it matches you to an attorney who can then work with you free of charge as long as you meet the requirements of the program. Now, it's important to still keep in mind that although the attorney fees are free of charge, the USPTO fees would still need to be paid by you. There are also law school clinics, and Jennifer will be going over them briefly, but basically they allow law students enrolled in a participating law school's clinic program to practice before the USPTO under the guidance of a law school faculty clinic supervisor. And more information can be found at the links at the bottom. And now we come to one of my favorite local resources, the PTRC, or the Patent and Trademark Resource Center. This is a wonderful place to begin your journey because PTRCs staff librarians versed in all things USPTO. They can help you navigate our tools, point you to the right place, and they can even teach you how to use our patent public search, which has really strong parallels to the search tool we use as examiners to find prior art. So I would highly recommend checking out your local PTRC. And as we can see, there's a PTRC at the University of Washington's Engineering Library. And finally, here's a compilation of links that go into more depth on each specific matter. So we have links to a patent application guide, the patent process, a patent search guide, resources for inventors, the Pro Se Assistance Program, and microentity information. And with that, I thank you all for your attention. I truly hope that this presentation helped you gain a sense of intellectual property. So now I want to open up the floor for any questions that you all may have.
I don't currently have any questions. It was just a lot of information. So I'll go back over the presentation later and digest.
Sure. And if you have questions then that you can formulate, you can send that question to siliconvalley@uspto.gov.
Hey, this was a great presentation. Can you hear me?
Yes,
Ballroom?
I have you.
So my name is Tracy. I heard about this through Jay Lyman. So hey, Jay, thank you for sharing. Two questions. I actually don't know if you said this in the very beginning of the presentation, but it's actually related to the concept of copyright. So I'm an author, I'm a trainer. I've come up with proprietary methodologies related to diversity and inclusion and leadership. And so as I use that language, I believe, and I haven't formally copyrighted it or trademarked it. I know it's not a trademark, but it's words, right? It's phrasing, it's processes, etc. So I think it's the TM that you put on when you've it's been printed in a book. So I'm also an internationally best-selling author, and our fourth book, it's actually one of the chapters is by that title. Isn't it kind of like inherently copyrighted? But I want to start using it more frequently, and wanted to find out what I needed to do to formally trademark, copyright, or whatever the right terminology, and what is the TM that I put on top of it versus the circle R, which I think is when it's officially registered.
So with copywriting, it's yours is a literary work, so it wouldn't necessarily be a trademark. I would recommend you do go to copyright.gov. Have you checked out that website before?
I believe perhaps I haven't formally finished the process, but I'll check it out. Copyright.gov.
I can even see if I can pull this up here. There we go. But that has a good list. Like you have, let's see here. I believe, yeah. So with this, if you hit research on copyright.gov, this will get you, based on what your general question is, in that right field to find out more. I don't know if you can see my screen, all of you.
Yeah, I can see it. So the difference between a TM and a circle R, do you know the difference?
The difference between TM and circle R, so TM would, so now we're going into trademarks. TM would be, you would be using the TM logo when your product is in use, or your logo, brand, service, whatever is in use in that particular geographical area. Now with Circle R, that's where you would file your trademark to the USPTO so that you will have protection across the entire United States.
Okay, thank you. And the circle R after it's done or when you're in the process of filing?
Great question. So Circle R, I believe, can be used after that trademark has been officially registered and approved.
Thank you.
Yep.
Thank you for the question, Tracy. We got another question that came in through the chat that I'm going to ask out loud. What kind of for a character or a mascot design, would they be able to trademark that, or is there another kind of intellectual property protection that could happen with that?
That's a great question. Yeah, so trademark, or for mascot designs, that would fall under the category of trademark.
Excellent. Keep the questions coming too.
I'm hoping for more patent questions because that's my particular field of expertise.
Any patent questions? Anyone has a
Actually, I do have one. So we ran into this I'm a supplier of items for laser engraving, and we order from overseas. And there's several other suppliers also. And we brought in cocktail smokers. And then shortly after we got the cocktail smokers in, a corporation got a design patent officially granted, and so then started to shut down all the Etsy stores that were carrying them, and contacting the suppliers and all of that stuff. So it was quite the interesting process, but they had a design patent, not a function patent. And so we have been trying to figure out, well, how do we fight this? Because these smokers were around for a very long time. And then all of a sudden, this entity has a patent.
Great question. The best answer that I can give you with that is, talk to the right people, and that would basically be hiring counsel, like an attorney, and they can provide you with a lot more detailed answer and give you the options that you would have on how to continue doing your business.
Okay, so how does the patent get granted though? Like, what research goes into it? Like, if there's already all of these listings on all of these websites, on Etsy, on Amazon, on all of these, then how can they prove that they are the ones that have the design for it? Like, how does that process work?
So right now, the US, we operate under the first inventor to file system. So I'm not sure about the details of which design patent it is, but maybe they had some nuance on their actual design or the shape, and they kind of have a better priority date or a earlier filing date than what's already out there.
Well, in this case, none of the other entities filed for a patent. So it was whoever filed for a patent first gets the rights to it, not who actually came up with the idea, I guess, because there's
Well, so
other.
basically, like when you're searching for prior art, that's prior art is basically just the term we use for finding a reference that is out there in the public domain that you would use to say, hey, you can't get a patent on this because you would be infringing on this apparatus. So maybe in that design patent, well, like if it's on Amazon or Etsy, that is part of public domain. But maybe the examiner that was examining that particular design patent
Mhm.
saw enough structure there on that design patent that was different than what is out there in the public domain.
Okay. Thank you.
Sure.
Thank you for those. We've got a couple questions coming in. I'm going to ask a question that came in through the Q&A part of things. Is adding the Circle C copyright to the material I share via social media or my website enough to avoid plagiarism? Do we still need to copyright this material, pictures, quotes, videos at a later point?
That's a great question. I, at this moment, do not have a great answer for that. If you could send that question to Silicon Valley USPTO.gov, I can look more into it. Copyrights is not, it's like a separate form of IP that I personally don't interact with on a day-to-day basis. So I'll look into that for you and give you, or at least get you the right POC for that question.
Thank you. And then can an app be patented if it uses additional technology that supplements the workflow of the app for a successful user experience?
That is, I think that's one of the questions of our times, to be frank, because you're talking about coding essentially, right? So the real answer, the real world answer is that it really depends on how you've written your patent application, what process or what part of the process you're actually patenting, and then also considering that someone can open that source code and kind of do the same item differently so that they would overcome your patent by just coding a few extra lines in a different way, right? So those are things that you would need to consider. Best answer I have for your particular question would be, maybe like a one-time consultation or a free consultation with an attorney in that field.
Also, to add on, this is Gautam Ubale. I'm a patent examiner in business method. I think the other thing I think it's a process that you're talking about in an app, that the way it's a method, basically. That's what we treat as. And for that kind of thing, it, like how Balaram mentioned, it depends. So how intricate is your software that you're trying to patent? It completely depends. If it's a technology improvement, I think there you can get a patent, but again, it depends on the intricacies of how complicated that software is, and was this been done before previously, which is where the prior art comes into picture. So it's completely dependent on what it is and how much detail you have in the description or the specification when you file it.
And another thing to note, so next week, I believe Jara, in her presentation, she's going to be going over a patent application. And so she'll be talking about part of the patent application is claims and your claim language itself. And that's where Gautam's mentioning where how much specificity are you putting into your claim language so that it can overcome that 35 USC 101 code that we talked about in the middle. I can pull that slide up. Right, so you have process, machine, manufacture, composition of matter, and it honestly, it just depends on how you're describing that code or that process, really.
All right. The next question that I have, I'm going to skip ahead because I just want to stay on topic here. And I think, could you talk a little bit more, and maybe you've already kind of answered this, but talk a little bit about the machine or transformation test and how it's applied?
Machine or transformation? Machine or what was the transformation part?
Machine or transformation test is the question. And it related to patent for code.
I guess this is maybe talking about 101 eligibility, and so go with them with business methods. You might run into that a bit more if you want to expand on that. I think that's what the question essentially is asking.
Yes, so I think the process or method that you file for, it has to be utilized on a computer, which is a machine. So I think that's where it all comes into down the line. Hope that answers it. If you still need more detail, please you obviously you can email us at siliconvalley@uspto.gov. We can add more detail of what you are specifically looking into too.
Thank you. And then for patents, is there a general turnaround time for examination and approval?
That's a great question. So Jara next Monday, she's going to be going really into depth about that. I believe the current timings, and these are like average timings, we're looking at about 17 months, 16.9 months from when you file to when you get a first response back from the office. And then your average time for reply. So you do have 3 months to reply, but you can extend your time for reply up to 3 months. So you pay by month. So you're granted 3 months, then you can buy a 4th month, 5th, or 6th month. So your average is about 3.9 months for replying. That's like kind of like the average we're seeing. And total, unless your application just gets approved and granted right away, you're probably looking at about a close to 2-year window. Gautam, am I remembering that correctly?
Yes, I think that sounds right.
But yeah, the actual specifics, Jara has a great diagram that she'll go over next week.
And I'll make sure to put that link to sign up for that in the chat as well. It's the same time, 10 a.m. next Monday. So you can sign up for that one too. Before we get too much further into the questions, I think we got a couple more, but I want to give some opportunity for those that might have questions they don't want on the recording. So let's just take a quick sidestep, and I think both Jennifer and I wanted to share about some upcoming programs and services. Professor Fan, do you want to share first, and then I'll go?
Okay, sure. Thanks, Jay. Sounds good. So I just wanted to talk a little bit more about the resources that were mentioned earlier by Bahram, including the Entrepreneurial Law Clinic, which is run by the University of Washington School of Law. So we represent microenterprises, high-tech ventures, nonprofits, and social ventures. And as Bahram mentioned, it's staffed by law school students who specialize in the areas of corporate and intellectual property law. We are part of the USPTO Law School Clinic Certification Program in trademarks and patents. So this means that our trademark and patent applications, at least at the first go-round, are seen on an expedited basis. Although there's no promises made after that, but it generally tends to be a bit faster because there is a dedicated patent and trademark examiner that works with just the law school clinics across the country who are part of this program. So we have successfully filed both trademark and patent applications for clients that have come to the clinic, and we represent clients throughout Washington State. It's a free service. It's a pro bono service. And so we welcome your application to the Entrepreneurial Law Clinic. In addition to that, Barbara mentioned the Washington Pro Bono Patent Network. We founded that about 6 years ago in partnership with the USPTO, and it's also funded partially by the USPTO and by the University of Washington, where we help pair low-income inventors with pro bono patent attorneys. I have my colleague here, Anna Bach-Metvia, who also helps to run that particular program. And Anna, if you could in the chat box maybe write down where people can direct their questions if they have questions about our program.
Sure.
And the last program that I'm going to actually have Jay talk about is one that we run with the Seattle Public Library, which is the Entrepreneurial Law Clinic and Seattle Public Library Library to Business programs consult sessions. We've done almost 300 of these consults to date, and it includes intellectual property. So Jay, I'll let you take it from there.
Thank you. Specific program that Professor Pham is talking about is a partnership that we've done where we have what we're really kind of referring to as a tier 1 service, which is a place for you to get some of those initial questions answered about intellectual property law, or we also have a corporate law set of them as well. They're 30-minute sessions with attorneys that the UW ELC recruits, and so these are attorneys who have expertise in either intellectual property law or corporate law. And so you can spend 30 minutes with them, ask them questions, and really start to orient to and go a little bit deeper into getting specific questions answered. At those, something to note, we don't form an attorney-client relationship as part of that, which means you retain your responsibility for your own legal matters. They're not going to be able to do work for you. But we find that it can be really helpful for folks to get those specific questions answered in that one-on-one forum, because then you can start to understand, is this something I could do myself? What pieces could I do myself? Do I need to hire an attorney? And if you do, maybe what questions should I ask? Sort of really orient to your specifics that you might need to know. So we have some coming up. The next sessions, we actually have some today, but they're all full. So the next sessions coming up are on December 5th, and I'll put the link in the chat. I believe there are some available sessions on December 5th. So sign up for those. And if you're interested in the corporate law ones, there's some of those available. I think there's some of those sooner as well. So I'll put both links in there so you can sign up. In addition to those, I wanted to also share about some other library to business programs that we have coming up. So even as soon as this Wednesday, we have some other kinds of workshops, not legal related, but business development related. So this Wednesday we have one on goal setting, practical steps to achieving your goals. We have on Thursday one on marketing basics. We have things on, of course, next week we have the patent process one that we talked about. A series on using Google tools, free tools, in a business setting. So how to use Google Sheets, Google Sites, and those kinds of things. So lots and lots of stuff. I'll put the link where you can find all those and sign up for them. They're all free. They're all virtual. Most of them are recorded, but not all of them. So sign up and we'll and attend those. Is there anything else that any of the other presenters want to add at this point? Anything else before we turn off the recording and have a couple minutes for? Okay. Well, I want to thank everyone. If you're listening to this and watching this after the fact, thanks for watching, and hope we'll see you at future events. If you're here live right now, you can stick around and we'll take other questions that you might want to ask us. So thanks all.